Hello, everybody. Welcome to a very special edition of the Mel and Charlie Show. Tonight, we have a special presentation, guys. And let me explain real quick. Many of you probably don't know, but I've been involved with Legal Shield now for over 20 years. In fact, September made 21 years. Legal Shield is basically what we do is we offer family legal family plans. Excuse me, uh, legal plans for individuals, families, as well as small businesses. And, you know, over the years, I have been getting so many questions, legal questions, issues, and typically I refer them right over to Legal Shield to get some assistance. Since COVID, a lot of people have been inquiring about estate planning, wills, trusts, uh, advanced healthcare directives, and so forth. And I'm not a lawyer. I am not a lawyer. I don't pretend to be one. My joke is always, I always wanted to be a lawyer, but I found out my test scores were too high, so I had to become a police officer. But so I felt, you know what? I've been a member of Legal Shield now for many, many years. Our law firm, our provider law firm for our members, is the law firm of Brevard and Jones. They're located right there right downtown Honolulu. And one of the partners, a good friend of mine, Ward Jones, who I'm going to bring on right now. Aloha, Ward.
Aloha.
Ward is new to this. He does these Zoom things only for court and trials and stuff. So anyway, I figured rather than we try to uh, Google search our way through estate planning and how important wills are and trusts and all of that stuff. Most of us don't even know the difference between a will and a trust. I asked my good friend Ward Jones to see if he would be willing to come on and share with us a little bit of estate planning and to give us some ideas of what we should be preparing for and how important it is. So, Ward, thank you again. How's it going there in the big city of Honolulu?
We're doing just fine over here. Opening back up, and glad to see some businesses are reopening, and people been through a lot, but they seem raring to go. So I'm looking forward to getting back to normal as like everyone else is.
Absolutely. Now, tell us a little bit about your firm and what kind of changes or adjustments you've had to make. I mentioned the Zoom court appearances, but uh, a little bit about your firm, where you're located, and how has COVID affected your practice?
It's affected it significantly because both my partner Bernie Brevard and I do courtroom work, and if you're not aware, the courts have been partially shut down and not allowing jury trials, and really discouraging parties and attorneys from showing up live for hearings. And in the interest of protecting all of us, as well as court staff. So that's the way it's been. But there are signs that next month they're going to at least start trying to catch up and conduct some trials and let people back into the courts, including juries, to do their work under the Constitution. But for last year and a half, I've not done a live deposition. It's all been on Zoom. 90% of my hearings have been via Zoom or WebEx. And, we've all gotten used to it, but it in my opinion, isn't quite as effective as sitting eyeball to eyeball with a witness. But we got to do what we got to do to get things done. The nature of our practice is such that we already had attorneys working remotely from home, and when COVID started coming on strong, we had more of our telephone people working from home as well. But I'd say in the last few months, we've got most of our staff back to work at our offices here downtown on Alakea, right across the street from the traffic court. And but we still most of our attorneys that handle telephone consults, write letters for people, and analyze documents are working from home, and they actually like that, so they don't have to suffer the commute into town, and so we've been kind of geared in that mode even before COVID.
Yeah, I know in the few times I've had to have an attorney. In fact, I've used your firm so many times. Been very satisfied. I'm a very happy customer or client.
Good.
It's so much better to be able to speak to an attorney and not through a Zoom. But anyway, so ladies and gentlemen, again, thank you for joining us. We have Ward Jones. He's a partner at the law firm of Brevard and Jones right there on Alakia Street on Honolulu. I'm going to turn it over to Ward. I've known Ward for a long time. When I was a private investigator here on Kauai, I've worked with Ward on some of his civil cases, and it's a great attorney, great guy, good guy. And I'm going to turn it over to him, and we'll get started with the presentation. Once we're done, guys, you guys have questions, Ward will be here to answer them live for you. So don't post your questions during the presentation because we're not going to put it up. Once the presentation is done, Ward will be able to answer any questions that you may have. All right, Ward. So let's go. Let me see if I can make this work again.
Thanks, Mel. Okay, folks. What I wanted to do here today is go over some of these words and concepts you hear from estate planning and give you kind of a simple definition of what those mean, because people throw them around loosely and it's very confusing. This talk is meant to be very basic. I apologize if some of you are more sophisticated and know all of this material already, but I wanted to just present an elementary approach so that perhaps you can remember these concepts and use them for your own family or friends and people that you love. So I call this estate planning basics, and I'm going to cover some of the documents that attorneys who practice in this area commonly create for people. Okay, what is estate planning? Estate planning anticipates the inevitable death that all of us will one day face. People don't like to talk about death, especially local people. They call it bocce and feel like it's bad luck to bring it up because you're going to hasten it. But you cannot think that way in the area of estate planning, because it's going to happen to all of us. And the problem is we don't know when. So the best thing to do is plan ahead for it. I had a very sad case come in last week in which a member lost both his mom and dad within an 8-day period from COVID. And it just hit me how fragile life can be, especially when something as terrible as COVID is about. And so it's something that probably anybody who's been vaccinated does not have to worry about, but there are still many other conditions that can cause us to leave this life, and therefore we have to plan ahead for it. Estate planning allows a person to determine, obviously, who will inherit his or her assets, who will get their stuff. Estate planning allows a person to determine who will care for his or her minor children. Estate planning gives instructions to your family and doctors on end-of-life issues. And estate planning allows a family member to act on your behalf if you are incapacitated. Now, this isn't everything estate planning does, but it's some of the most important ones, in my opinion. First concept I wanted to discuss is, what is a will? Everybody's heard of the word will and probably have some idea what a will is. But if you want to get technical, a will is something, it's a document, and it's recognized in every state if it's properly prepared and executed. In Hawaii, a will must be prepared in writing, usually typed, signed, witnessed by two adults, and notarized. Now, there's exceptions to that, but if you follow those main elements I just read to you, a will like that is called self-proved, and it will sail through the probate process without any problems. You will not need witnesses to testify to the validity of that will. That will is what's called self-proved. You can use a will such that you can give anything you have to anyone you want, subject only to protections of your spouse, which are protected by statute. That's called elective share. So you cannot completely exclude your spouse from getting anything, but you may exclude virtually anybody else. A will allows you to set forth your preference of guardian for your minor children. Now, that means you just list the person that you want your minor children to be taken care of. But ultimately, the judge has the decision making on that issue, but gives strong preference to your preference. The judge is always looking out to protect children. And if, for example, someone you chose turned out to have some history that causes concern for the court, then only in that situation might you be second guessed by the court. A will allows you to name an executor or personal representative of your estate. Think of an executor or personal representative as basically the financial manager of the estate. A will does not avoid the court process known as probate. The will must go through the probate process to be effective. A will can set up a trust for others after it is probated. Now, I don't want to get ahead of myself here, but there is a way to incorporate a trust into a will, but that's only after the will has been probated through the court process. That's, in fact, how it used to be years ago. People commonly wrote trusts into their wills to make the will extend to their children or later generations. Now, what happens if you don't have a will? The world's not going to come to an end, but your legislature will determine where your property goes that is in only your name, according to a set of laws called intestacy. Now, there's nothing wrong with the laws of intestacy. They kind of follow the natural distribution that most people would prefer. For example, if you're a married couple and you have no children, most people in that situation, if they died, would want all of their property to go to their surviving spouse. And that's exactly what the intestacy laws say. Or if you're a married couple and or if you're a single person and you have children and you passed away, most people would want their property to go to their children. The problem is it gets more tricky if you've got situations where perhaps you have children by a prior marriage, or you don't have any spouse or children, and so it goes under intestacy, it goes back up the chain of title to your parents and then down to your brothers and sisters if you don't have living parents. So then it gets a little bit more tricky, because then you don't know if you want your property to go to your siblings or perhaps to their children. And so if you want to avoid unintended consequences like that, then it's best to have a will, because otherwise your property could end up in the hands of a distant nephew or cousin, maybe somebody you don't even like, and that would be tragic, and you'd be doing yourself a disservice. Okay, the next concept I wanted to discuss is what is a trust? Trust is another document that attorneys draft for people. It is similar to a will in that you can determine who gets your property. You get to pick an executor, which they call a trustee, same thing. And you can also designate the guardian of your minor children, just like with a will. However, a trust is really the most popular way to avoid probate court. And the reason why so many people want to avoid probate court is the cost and the time involved. A trust document, just to buy one, it costs more than a will. In Hawaii, it averages about $4,000 and up for a trust for a married couple who have maybe one property, their residence, and the attendant documents that attorneys draft that go with the trust. And so that's really the issue, is whether you want to pay that kind of money to avoid probate now, or just go with a will and let the cards fall where they may and pay the costs of probate. So it's a pay now or pay later choice, really. Other things that a trust can do is that it may help reduce taxes, and you hear about death tax, which is something that that used to be a concern when I was first licensed way back in 1981. Back then, the threshold where the death tax kicked in, it's also called the estate tax, was only $1 million. And so if you had an estate worth more than $1 million, you had to plan for the possible death tax exposure. And of course, Hawaii, homes are so expensive here. It's not that hard to end up with an estate of $1 million. But since then, the estate tax is way up, $4 or $5 million per person, and most of us don't have that kind of estate to worry about. So it's become less and less important for estate planners to plan for death tax. And so, but let's say you had a large estate like that. What you can do is do a special provision in your trust to avoid any harsh effects from the death tax, and take advantage of what's called the Marital Exemption, which allows you to leave an estate of unlimited size to your spouse without being taxed. And if your estate is over that amount, you can include a provision that allows you to leave the estate to anyone other than your spouse to reduce the effects of the estate tax. So you split your estate to avoid death tax legally. A trust is a little bit different from a will, because when you don't have a trust and you die and you have a will, the will gets filed with the court, and so it becomes a public document. A trust, however, doesn't go through the probate process, and it's kept private and confidential. A trust can be what they call revocable or irrevocable. Revocable just means changeable, amendable. Irrevocable can't be changed. And the most common trusts are the revocable or changeable kind. I've had clients amend their trusts 10 times because of life changes in their circumstances. Grandchildren, divorces, acquisition of new properties, sale of old properties, all of those things cause people to rethink what's in their trust. A trust can allow you to be your own initial trustee, meaning you're the manager of your own trust as long as you're living and competent, even though you're a beneficiary of it while you are alive. Now, what does a trust document look like? It too must be written, signed, and notarized, but it need not be witnessed. Once a trust is created, it's very important to fund the trust, which means to place your property into the trust, such as real estate, bank accounts, or personal property. Think of a trust as just like an empty glass that cannot do its job until you fill it up with your property. A trust can eliminate the need for a conservatorship if you become physically or mentally incapacitated. Conservatorship is a costly court proceeding to appoint someone to manage your financial affairs if you don't have a trust. It can run into the tens of thousands of dollars to have a conservatorship set up. If, say, you become physically or mentally incapacitated and have substantial assets to manage. With a trust, your property remains available to you without court supervision. Your successor trustee, the person you've named in your trust to take over after you become incompetent or die, takes charge, manages your assets, pays your bills without any interruption. That person will have immediate access to your former bank accounts, your properties, etc. One of the terms people throw around is living trust. Think of that as the same thing as a revocable or changeable trust. And virtually all the trusts we write at this law firm are revocable trusts. People want the power to change them if they have to. A trust looks different from a will. It's a much thicker document. The ones we put together are averaging about 50 pages. There's a lot of provisions in there that give the document more flexibility. For example, trust can continue on for generations and address specific financial needs of individual heirs. It can specify conditions on use of individual properties, who gets to use them, who gets to live there. It can distribute principal or income or both in prescribed amounts at different times. It can prescribe conditions on inheritance. One example I like to use is, well, I'll give 25% of my money to my son if he graduates college. I've had clients ask for provisions like that, and even more specific. I've had clients say, my son or daughter will only inherit if they overcome their drug problem or overcome some other problem. So sometimes trusts are used to try and influence behavior of our loved ones. Another document that most estate planners will draft for a client that comes to them and wants either a will or a trust is something called a durable power of attorney. In the event of medical incapacity, such as a stroke, you will not be able to sign any legal documents such as checks, tax returns, contracts, or deeds because you'll be considered incapacitated, and those documents will be questioned as being illegal because they were not signed with sufficient mental capacity. So the power of attorney, which must be in writing and also notarized, allows you to designate someone to handle these tasks for you in a situation where you don't have a trust or don't have a successor trustee to do these things for you, or if you have a trust but you do not want the successor trustee to take over yet. You can make it effective. You can make a power of attorney effective right now, or only upon your incapacity. The power of attorney can be used while you are living, but ceases to be valid after you die. It can be canceled or changed while you are competent and living. You may provide for successor agents if the named agent cannot or will not accept the task as your agent. Now, one thing I want to mention about durable powers of attorney, they can be misused because the person you designate as your power of attorney can access your bank account, sign deeds to your property, do virtually anything you could do. And so you must be careful that you really know this person and trust this person and have confidence in them, because I've had a number of circuit court cases in which, unfortunately, powers of attorney have abused their duties and harmed their principal, and lawyers were needed to try and undo the damage. Now, the next document that usually makes up part of a good estate plan is something called the Advanced Healthcare Directive. Now, if any of you have gone to the doctor lately and had any kind of surgical procedure, your doctor probably asked you if you had an advanced healthcare directive, and that's why. And the reason why they doctors are concerned with it is because if something unplanned happens to you during that medical procedure and they cannot revive you, or you go into a coma, that advanced healthcare directive is your instructions as to what to do. Advanced healthcare directives are sometimes loosely referred to as living wills, not living trusts, living will, and it allows you to make end of life decisions and must be in writing and notarized. Now, end of life decisions means, and there's a statute in Hawaii that lays all this out. It means if you have an incurable and irreversible condition that will result in your death within a relatively short time. I use the example of fourth stage pancreatic cancer. Most people who are familiar with that one know that your prognosis is very poor. That's the one that Stephen Jobs died from. Another example that qualifies as an end of life situation is if you become unconscious and to a reasonable degree of medical certainty you will not regain consciousness. Example there would be get in a car accident and are in a coma, and the doctors don't think you're going to come out of it. The third one is the likely risks and burden of treatment would outweigh the expected benefits. Certain kinds of cancer they offer no treatment for that's medically recognized other than experimental treatments possibly. And so if you have something like that, bone marrow cancer, fourth stage, for example, then that would be something where that might be considered an end of life decision. Now, end of life decisions include whether to provide artificial nutrition to that patient, extra hydration, blood transfusions to keep them going, a respirator to aid their breathing, painkillers to address their pain, often in an intensive care environment. The medical expenses for patients like that obviously are huge, and not everybody wants all of that expensive medical care to keep going, and so they may specify exactly which of those they want or don't want. Many times religious beliefs figure into those decisions. The reason why this is important and why your doctor asks whether you have an advanced healthcare directive is because they are trained in medical school to use all available science to keep you going, unless somebody tells them otherwise. And And so your advanced healthcare directive is a way for you to have a voice if you get into that unfortunate situation. Another item that these advanced healthcare directives address is organ donations after your death. Now, the ones we do and the ones many law firms do is really a two-part form that attaches something called a medical power of attorney as well, and it's a limited power of attorney to address decisions regarding to address medical decisions concerning you if you're unable to make those decisions yourself. The doctors will always try and check you out to see if you can make the decision, but if you cannot because of any of the above situations, then your medical power of attorney agent can make those decisions for you, including where you'll be taken, what medical facility you'll be taken to, what medical tests will be allowed, what treatment you'll be given, what surgical procedures will be performed on you. And any of you have been in a situation with a parent or loved one who cannot function and cannot make their own decisions, and the doctors turn to the family and say, well, what do you want us to do? I've seen situations where the family starts fighting, and it's a terrible time to start fighting when a loved one is their life and future is in the balance, and the family cannot decide what to do. A way to take that burden off the family is to have an advanced healthcare directive and a medical power of attorney. Then that person will make the decision based upon what you filled out in that form. It's like your instructions. And so the person you select as your medical power of attorney is really different from the person you might select as a trustee who handles your assets. The person who handles your assets should be good at financial matters and understand your philosophy on things and be familiar with your assets. But the person that handles your medical power of attorney really has to know about your personal medical preferences and beliefs. And so they're not always the same person. So it's just something to think about. One other thing too is that, some of you who have elderly relatives may have gone through something called a guardianship, and that's a situation where your relative can no longer make day-to-day decisions for themselves because they've become senile, sick, or infirm, and maybe are totally out of control. And so in that situation, if you do not have a medical power of attorney agent to make these decisions for that person, you've got to go through a costly court proceeding called a guardianship, in which the court appoints someone to oversee the protected person. And it too is just as expensive as conservatorships because it's all decisions have to be filtered through the court. And so just by doing this simple advanced healthcare directive and medical power of attorney, you can actually avoid that major expense of a guardianship. So I strongly recommend it. Okay, I've touched a little bit on what a probate proceeding is. Most of you probably have some understanding of it. But in a nutshell, it's a court proceeding in which your will, so let's say you don't have a trust, you just have a will, your will is filed with the court and reviewed by the judge or a court employee called a registrar, and they will try to follow what the will says and appoint the executor that you've listed in your will to manage your estate. And these executors or managers first have to gather and protect the estate assets, because a lot of times they don't even know what you have. So they try to do an inventory, visit your home or business to take stock of what you have, notify all known creditors that you've passed away and that an estate is being set up, and then to deal with those bills and taxes, if any, and pay those things, and identify and notify all heirs who are listed in the will, and prepare, after all that is done, prepare what's called a final accounting of assets, debts, incomes, and expenses, and list the proposed distributions to the heirs under the will. Probate expenses average about $5,000 and up if there's no fighting going on between heirs, just for attorney's fees and costs. And the practice is to charge hourly for this type of work. And if you go through a formal proceeding overseen by a judge, it'll take a minimum of 9 months. I do probably 10 to 12 probates a year, and most of them are not contested, but if they do become contested, they can get far more expensive. Examples of contests or disputes in probates would be perhaps if a creditor's claim is contested as not being bona fide, or sometimes a person will bring what's called a will contest and actually challenge the validity of the will, saying, hey, I've got another one that supersedes yours. And so you have to have a trial over those types of disputes. And so if a person dies without a will and he or she has property in their name, an intestate probate proceeding is filed in court. Excuse me. It's similar to one with a will, except the distributions are made according to Hawaii statute. And the costs are similar. So after hearing all these bad things about probate costs and delay, the logical question is, how do I avoid probate? The most popular remedy is have a revocable trust prepared and to transfer your real property and other property into the trust. Then you will avoid probate. Now, if the cost of a trust is prohibitive for you because of your situation, there are less expensive ways to at least perhaps avoid probate if you have real property, which is one of the most common concerns, and that would be to be careful how you title your property, how you hold your property. If you hold it jointly with right of survivorship with another party, or as tenancy by entirety with your spouse, then when you pass, that title will automatically go to the other owner and will not need to go through court. If property, on the other hand, is held as what they call tenants in common, it does not avoid probate. Also, if both joint owners die at the same time, that also doesn't avoid probate. The last owner will still have to go through probate. Another type of document that's come up in the last 20 years under Hawaii statute is called a transfer on death deed. And this could be used in a way which designates a person to whom your property will go at death. Commonly, parents will try and use this one to designate a child as the person that gets the property when they both die. That's a low-cost device to avoid probate. Bank accounts, like real property, can be held jointly, or what they call POD, payable on death. And you have to set those accounts up that way with your banks. But for example, most married couples have what's called a joint checking account. And if one of them passes, the balance of that account automatically goes to the survivor. Does not have to go to court. But there's more fancy types of accounts like payable on death, where you name a person who's basically a beneficiary who gets it when you pass, but while you're living, they have no access to the funds. Retirement plans, 401ks, IRAs, those are not dealt with by way of a will or a trust, because those are purely contractual with the companies that manage those plans for you. And so you have to pay attention to what they call the beneficiary designation form. It's a simple form, but it's got a lot of effect. And it's important to be aware of what you put in that form when you first open the account, and to check it every few years to make sure it still reflects your desires. So you control that entirely by filling out the designation of beneficiary. Same thing with insurance policies. Those are contracts between you and the insurance company. And so you cannot alter that relationship through a will or a trust. You need to monitor your beneficiary form and fill it out in a manner that you desire. Insurance companies and retirement plans are very careful to verify who's on that beneficiary form, and when they show up for collection, they're very careful about verifying identity, because they're liable if they give the money to the wrong person. Another device that used to be popular when I first started practice in the 80s, but it's hardly used now, it seems, is tax-free gifting. By doling out in small amounts legal gifts to, say, your children or grandchildren each year, you could avoid any gift tax or inheritance tax. Bear in mind, though, you cannot avoid capital gains tax in the case of stock or real property that has increased in value over time. Those are still subject to income tax. Small estates of under $100,000 with no real property in them can be handled in a way that avoids probate through a document called an affidavit of collection. Now, not all banks or companies will accept them, but many do, to transfer an asset to the rightful heir. And basically that's what that affidavit says. It says, I swear that I'm the rightful heir and the only heir, and you may transfer that bank account to me. And so those are commonly used. So what to do now if you don't have a will or advanced healthcare directive? Since we service the Legal Shield plan, Legal Shield members actually get a free husband and wife or significant other will and advanced healthcare directive as part of their plan at no additional expense. And we will, after receiving a questionnaire, fill one of those out for you within 5 days. And I'm happy to say, as of 2021, we've got about 10,000 10,400 Hawaii members throughout the state, and we've drafted somewhere around 4,500 wills. So we still got more work to do, but that's a lot of wills, I can tell you. If you're not a Legal Shield member, the thing to do is contact a lawyer who does, wills and trusts, and ask to get one. And the cost will be around probably $400 to $600 on the outside, but it's well worth it to ensure that your stuff will go the way you want it to. Same goes for a trust. If you're really fearful of the probate process and the expense, and you want your kids to avoid that expense, then you can explore getting a trust set up for you and your significant other, and then transfer your real property and other assets into the trust. So with that, I think that's all I had. Mel, if we wanted to field a few questions. I'm sorry I went a little long, about 45 minutes, I guess.
Thank you very much. I noticed on there you talked about the online forms. Be careful using online forms. Could you touch on that real quick?
Yeah,
I know. Go ahead.
We're in the online era where people love to Google, and there is a lot of forms online, many of them free, but please be careful, because if you don't know what the requirements are, you could be using something from another state, or misapplying it and not filling it out correctly. I had one case, believe it or not, where this guy, he had a $3 million estate, several big homes, and he went with the online forms and didn't do it right. And we had to go through an expensive proceeding of gathering what his intentions were. He used an online trust and forgot to put in a distribution scheme in it, so nobody knew where everything goes. And so, and I've seen a similar problem with even wills, which is a simpler form, where people have not set them up right, and had ambiguities inherent in the way they wrote it, so you couldn't really figure out what they were intending to do with all the property. I know it sounds like a simple thing, and how can anybody mess that up? But believe me, people do. And so it's one of those things where you're being penny wise and pound foolish, as they used to say. So I would avoid online forms.
All right. Well, thank you very much. I know some people are asking for contact. I will post. If you guys want more information, feel free to go ahead and shoot me a private message. This will be on YouTube. It's on YouTube live right now, but once I'm done, I'll go ahead and put in some links on the YouTube in the description. I just wanted to, we're going to do some questions right now, because I see a bunch of them rolling. Here we go. We'll just start right here. If you have a will, does your estate go to probate?
Yes. If you don't have a trust, then when you die, suddenly your property is in limbo now. It's still in your name, but you're no longer alive. And so an estate has to be opened up, and they will use your will to do that. And so the will be filed in court, and you will have to go through probate.
Can you tell? Oh, I'm sorry. Can you tell us more about the Legal Shield? We'll talk about that. Our members on Legal Shield get, as Ward said, they get the will for both their husband and wife. Each gets a will. They both get the Advanced Healthcare Directive. They both get the powers of attorney. The trust is not covered under the free benefit, but you do get it at a huge discount. When we're done, I'll put up the link so you can get more information, or shoot me an email or private message with your email, and we'll send you the information. I would love to invite you to speak to family reunions pages about how important wills, trust, probates. I know. I gotta tell you, Ward is a great guy. I tell you what, I learned a lot tonight. I've been through so many will workshops, but this was the most impacting. How much does the entire documents package cost? Uh, I, let's start with the will. If you go to an attorney and get a will drafted, I think you mentioned about $300 to $400 a piece.
Yeah, it varies. I've seen them as low as 350, something like that. It used to be 250, but I think it's harder to find now. Maybe if you shop around, um, you can find it for 250, but it's difficult. So I'd say somewhere between 250 and 600 for uh, wills for just one person, and so they'll double it on you if you're going to do husband and wife.
For those of you on Kauai, I can tell you they run about $700. Of course, Kauai
Wow.
is always a little. Why would anyone prefer a will over a trust?
Well, a lot of people don't have the money for a trust. Um, it boils down to economics for a lot of them, and so I can't fault people if they don't have $3,000 or $4,000 to fork out for a trust. It's a lot of money for most people, and so um, we try to come up with things that uh, help them if they can't afford that, and but most commonly, if you own real estate, it gets tricky because if you die and the real estate's in your name, it's got to be probated, and so but it's not you paying it; it's your kids or your spouse. So that's the economic nub of it is your loved ones are having to pay that expense for the probate.
Yeah, I think that kind of answers the is it better to get a trust than a will. I think a lot of it is driven by economics. I know my mom had a will. She passed away. She didn't have many assets. It did go to probate. Probate. It was uncontested, and we did spend a few $1,000s on the probate, even though there was nothing wrong or contested.
Hmm.
There's another one that I'm not sure that. How do you do a transfer of death deed?
Well, it's just a document that looks like uh, any other deed you might have, but it's got some special paragraphs added in there that follow the statute, the Hawaii statute, and sets forth, you know, uh, who gets the property when both of the current owners or the current owner pass away. Um, it's not a perfect uh, solution because one of the problems is creditors can sometimes attack uh, the deed and try and attach because maybe your child has gotten into trouble financially, and so there are some situations where it's the transfer on death deed can cause problems, but it's the idea of it works, and if you know everybody handles themselves responsibly, it works for people and avoids uh, probate legally.
Does every bank do payable on death forms?
Yeah, most of the ones I deal with, it's just a type of account that's provided for under Hawaii statute, and uh, and when you set up the account, fill out the signature cards, and do all the stuff you do when you first set up an account, you specifically request that, and they'll have a form for you to fill out.
I had never heard of that. Thank you for sharing that. That is, where can someone get all of these documents done if they don't have the financial means to do so? Does any organization in Hawaii provide assistance? I will tell you that in my experiences working with Legal Shield over the years, probably 70%, 75% of the people that I've come in contact with don't even have a will. And as you mentioned, Ward, over 10,400 members of Legal Shield in Hawaii right now that have the ability to get a will, powers of attorney, and advanced healthcare directive done for free. Don't only out of only 4,000 people did it. I mean, I don't know if people just don't think they're going to die, or they just it's something that we can do later. We'll just put it off. But Is there some place that someone can go and get help with getting these documents without, aside from getting a membership, from getting these things done without financial cost?
I know the military guys can get some help uh, through judge advocates or whatever on base, but that's a special situation. They're going to go fight in a foreign country, and so the military has a stake in making sure they're feel confident before they get transferred. But I don't think legal aid will do that for you. Some of the union members might get limited help through their unions, but I doubt they'll get a trust. I think they'll get a will. But that's something, at least. But I can't, I've never heard of legal aid writing wills for people, and I've never seen one presented to me written by a legal aid lawyer for probate. Just, I just don't think they get involved with that.
Ward, how often should a trust or even a will be updated or reviewed?
Good question. Certainly, if you get a divorce, and then I think I think if you have kids, you got to start thinking about those kids, because now the family has expanded, and then if your kids have kids, reread that trust again or that will, because times have changed on you. Also, if, let's say, when you wrote your first will, you were living in one town, and then since that time you've sold that house and bought another one somewhere else, you got to make sure that your current assets are transferred into the trust. Otherwise, the trust doesn't do what it's designed to do. And I've had a number of cases where either family or lawyers forgot to transfer things into the trust, and they had to go through that horrible probate expense just to clear title to one piece of property. And so when you're buying real property, think about your trust and make sure you transfer it, because it's a sad day if you find out it's still in your name and not in your trust.
Also, I know, and I've seen this happen where credit unions give you all these different types of insurance. They come out with, it's a low level insurance, but you still have it. And at the time you got it, or when you sat in a presentation at work and you got life insurance, $50,000 policy, and at the time you were married to your first wife, and then you die, and as Ward said, that contract is not changeable by the will or trust. So your ex-wife or your somebody that you might not like may end up with your benefit because you failed to keep up. So it's important as part of your estate plan to make sure you update your documents as often as needed, because that can cause some grief. You'd be in heaven so angry because you see your ex-wife driving her new car with her new husband.
Yeah,
Can you add and I'm sure you've heard that story over and over. I'm sure, Ward, as an attorney, my lord.
yeah. The legislature actually came out with a law to help those poor, forgetful people, and it basically says if you get divorced, all bets are off on prior insurance policies and wills and trusts. But the devil is in the details sometimes, and it's a mess sorting it out. But the legislature has tried to save you if you go through a divorce and you forget to make proper transfers and changes in your stuff. So, but I've seen a few where it was still a mess.
Can you add a family member to your home title and it not be effective until your death?
Yeah, and that's they have to be an adult. Can't be a minor, but that's what a due on death deed is really. You put it in you and your wife's name right now, but you have your adult son, say, as a designated title holder when you and your wife pass, and your son will get it, but only when you're both gone. And so I think that's what legislature envisioned, and that's how people should use it.
I know I told Ward we'd have him on for an hour, so I'm going to do just a couple more questions, and then because it's just not stopping, and I appreciate that's a good thing. Advanced healthcare directives, is that a yearly thing, or is that one time and done?
No, think of it like your will. It's just a one-time deal, but certainly if your philosophy or beliefs change, you ought to reread what you put in there, because you might have changed your mind on things. A lot of that is also financially driven. We all want to live as long as we can, if our quality of life is good. But some of these measures that modern medicine will do for you are super expensive, and it can clean out your whole estate unless you've got a heck of a medical plan. And so it's something to think about. And not everybody wants to be kept going if your quality of life is poor and you're in a coma, and even if you come out of it, you're likely to have brain damage. I mean, so it's one of those tough decisions, but that's what the Advanced Healthcare Directive is supposed to do, is have you make those tough decisions for yourself right now, so that your family doesn't have to struggle with it or argue over what Ward would have wanted, or what Mel would have wanted, because it's not always clear.
The other thing too, and we went through this experience with my father-in-law. He unexpectedly had a medical condition. He ended up in a coma, brain dead. You get your advanced healthcare directive. Make sure it's filed with your doctor. Make sure it's in your medical report records. My father-in-law forgot that part. And it came to where my wife needed to make that decision, and that is a horrific decision to make as a child of someone that you love. We believe in God, we have faith, we hope for a miracle. The blessing of all of this was we all got together, we all were members, we all got the free advanced healthcare directive, so we all knew what we all filled out. So my wife was able to carry on his wishes, even though we couldn't find his document. So make sure when you do your advanced healthcare directive, you give it to your doctor and it's in your records, because you don't have time to be looking in safety deposit boxes. I think we'll do this one as the last one, because I think it's important. I thought as long as your will was handwritten, not typed and signed, that it was valid. Not true. Saw this on the news when a celebrity died recently. Family was contesting it, but court said it's valid.
Yeah. No, the answer is there is an exception. It's called a holographic will. And holographic wills actually came about or developed during wartime. Soldiers in the field would suddenly write out a will because they didn't think they were going to make it. And the legislatures from various states said, we need to accept those. And so Hawaii has a law where the court has the power to recognize a handwritten, signed will and enforce it. But it's not an easy process to go through. You're likely to have to call witnesses who were familiar with the decedent to prove up the will, and it gets more dicey too if the will is not doesn't address certain things, certain properties, or forgets certain people. Then it becomes more questionable, and people can then try and alter it or just challenge it altogether. But there are the court does have the power to recognize a handwritten will. I had a case where I had to cobble together several documents that the decedent had written by hand to settle his estate, because he had quite a bit of property, but only had a couple of little scribbles, pieces of paper signed by him to address all of it. And but it does happen, so you got to work with what you got.
I lied. Last question, only because I was going to ask this question earlier. How often should a will or a trust or any legal document in estate planning be reviewed by your attorney? And this Sharon is asking. I'm not sure if she's a member. Does Legal Shield review and update existing wills and trusts for members free, or is there a fee? First question: how often should you review?
Well, under Legal Shield, you're entitled to an annual review of your will and advanced healthcare directive at no additional charge. So after we write the thing up for you, we can look at it each year, and really, since we don't know what your situation is, whether you've had, change in your marital status or more kids or deaths in the family, we do rely on the members to tell us any new facts that help. So I don't think everybody, as a matter of course, needs to review their will annually, but certainly every few years I would, because that's, stuff happens and things change. And like I said, it's those life events that should trigger your thinking about all of your documents. Changing your marital status, changing your health, changing your job, changing your kids or your kids' kids. Unfortunately, there's times too, I've had cases where kids that were in your good graces suddenly become estranged. Maybe they develop bad habits or start living with people you don't like. That causes people to want to amend things and change their will. They become very concerned, and for good reason. I had one case where I went through a long trial because a couple divorced, and the parents were on title to the home, and all of them were living together. And so there was a danger that the family home where all of them lived would get sold, and the parents would be thrown out with no place to live. And so those are the kinds of things that people should think about in their estate planning if they're going to involve other members of the family on title.
Thank you. Thank you, everybody, for jumping on tonight. And thank you, Ward. I see you still at the office. That's a beautiful office, by the way. Jeez.
Thank you.
You guys have come a long way. But appreciate the education, the information. Again, people, this is Ward Jones, partner with Brevard and Jones. They are the provider law firm for Legal Shield, who happens to be hosting this workshop tonight. If you do want information on Legal Shield, you can go to the website www.mplss.com. That's our website. You can go check it out. Also, you're watching this live, but once we're done, I will have the links posted up and on our YouTube video and a YouTube description. So if you haven't been to our YouTube channel, it's Bell Raposo, my channel. Go check it out. Make sure you subscribe and click the bell icon so whenever we do videos like this, you get notified. Ward, any closing thoughts before we allow you to go home? No traffic right now. No.
Yeah, I got that to be thankful for. No, just everybody, take care of yourselves and take care of each other. No, thanks for having me.
All right, Ward, you take care. Give our love to the family and tell them thank you for letting us have you for an hour or so tonight. To all of you, we'll see you guys on Friday night. Dr. Tim Brown from the East West Center.